Hi, welcome back to StarPropertyTV. The escalation of property prices have forced many to resort to renting a home rather than owning one. As such, the topic tenancy in Malaysia has become one of great discussion in recent times. Today we have Christopher Chan, the Associate Director of Hartamas Real Estate, and Ivan Chan of Amir, Francis and Partners to give us a lowdown on this subject. Welcome Chris, welcome Ivan. So firstly, we'll start with the basics. What is a tenancy?
Okay. First and foremost, thank you very much. I would like to thank Star Media Group for inviting me here for the interview
Happy to have
on
you
this
here.
specific topic. I think, Jonathan, when you talk about tenancy, tenancy basically, tenancy or tenancy agreement is basically defined as a contractual relationship, simply put, between a landlord and a tenant, where the tenant agrees to pay a rental in occupying that particular property. And a tenancy is defined as a period that is not exceeding 3 years. Because once it exceeds 3 years, it will be called a lease.
All right.
Yeah, this is just a very simple definition.
And what are the main elements in a tenancy setting?
In an element setting, there are basically three elements in it. Basically, firstly, you have the landlord. Then second, you have the tenant. Then the third, obviously, is the property that the tenant is staying in, the real estate. So there are three elements component in the tenancy setting.
And talk about the applicable laws governing tenancy in Malaysia.
Okay, it's very interesting. For Malaysia, there is no a tenancy law, specifically addressing tenancy per se. There are basically bits and pieces that we take from here and there. So basically, you have firstly the laws that governs tenancy in Malaysia. Number one, you have, which is the main land law governing Peninsular Malaysia. That's called the National Land Code. So you have one. Then secondly, you have, of course, it's a Contracts Act. Then you have a Specific Relief Act. And then you have the Civil Law Act. And then you have Distress Act. And then last but not least, you have the common law and case studies that we can derive from there. And basically, these are.
How many types of tenancies exist today? And maybe elaborate on the differences between each.
Okay, I don't know. Quite a lot of people do not really know about this, but there are essentially three types of tenancies that exist. You have number one is the fixed term tenancy. Fixed term tenancy. Then number second, you have a periodic tenancy. And then the thirdly, you have is a tenancy at will. Put it very, very simply, Jonathan, the first one, fixed term tenancy. Fixed term tenancy is basically a tenancy that has a definite beginning date and an ending date. It's very easy. Second one, periodic tenancy. That tenancy basically is for some period of time, depending on the term of the payment of rent. So that particular tenancy can be from year to year, month to month, or week to week. And then lastly, tenancy at will is basically a tenancy arrangement between the landlord and the tenant, whereby there is no written contract governing the tenancy. But the tenant is occupying the premises, paying the rent to the landlord, of course at the landlord's consent. But there's no written agreement as to the payment of rent and also duration of the tenancy. So I hope you get it. That's basically the three types of tenancies that we have.
For the benefit of the viewers now, what are the important things one should take note of in a tenancy agreement, both from a standpoint of a landlord and also a tenant? Maybe Ivan, do you want to chip in?
Okay. There have to be certain major provisions to govern the tenancy agreement, and due diligence has to be conducted at the beginning to conduct searches on the landlord to ensure he is the proprietor, and also on the tenant, his background. Okay, and we have to ensure that all the proprietors sign the tenancy agreement in order to validate it. Okay, we don't want a situation whereby just one of the co-proprietor sign the agreement, all right? Okay, and then of course we are also looking at the purpose of the user of the property. What is it used for? And it's important that the tenant doesn't breach it. Okay, and then the option to renew is important as well. Okay, and then yeah, those are some of the things. Maybe Christian.
Okay, if I can add on the some of the things that elements that you're saying the main elements of a tenancy agreement to take note of. I think echoing what Mr. Chan has mentioned, I think the permitted usage is very important because there are cases where I find that sometimes it is purely a residential entity, but they use it for a commercial use, and vice versa. So things like that, we have to abide by the provisions under the National Land Code and also the council bylaws and so on with regard to this.
And what happens when a tenant defaults on paying rents?
Okay, that one is basically his domain. But before we go into the legal angle, usually what I would tell clients, the public at large, is that the legal recourse should be the last resort.
Okay.
The most important thing in a tenancy setting is that the landlord must have a good open communication channel with the tenant. Both ways. I think that's very important. It's like both of them are. The landlord should see the tenant as a business partner because the tenant is basically paying the rent, of the particular place, be it a residential or non-residential premises. So therefore it's very important that they communicate well. If there's any issues that they have encountered, talk to each other and things like that. I think that should be the thing, and try to work something out and resolve things. The legal angle should be the last one, but sometimes things happens in life, Jonathan. Sometimes we have left with no resort but to go through the legal resort, and that's where Mr. Ivan Chan will come in.
Okay, you were talking about what happens if the tenant defaults in payment of the rent. Okay, in that circumstance, the landlord's lawyer will have to explore the various options that are available. Okay, whether or not to continue, whether or not to claim the overdue rent and then continue with the tenancy, or number two, to terminate the tenancy agreement. All right. So if the tenant is not paying the rental, but the landlord wants the tenancy to continue, then the first thing is to issue a formal letter, okay, to inform the tenant of the breach, and then give him a certain period of time to remedy it. Okay, failing which, the landlord will reserve the right to commence legal action against the tenant. All right, and let's assume that the landlord wants the tenancy agreement to carry on. Then the landlord's lawyer may consider going for distress action to get rid of distress from the court. Okay, whereby the goods of the tenant will be impounded, all right, and then eventually sold at the public auction, all right, to meet the amount of the rental due and owing. That's first option, all right. Secondly, if the landlord doesn't want the tenancy agreement to continue, then he may explore the option of terminating the tenancy agreement and giving the tenant a notice to quit, all right, and then maybe if the tenant still remains there, then go for eviction, and then if the tenant doesn't want to move out, then go for writ of possession. Basically, it's just that.
But I'll play you a scenario. If you have a very uncooperative tenant, he changes his contact numbers, you cannot reach him. He might go AWOL, but the point is your unit is still occupied. his possessions are still there. What's the first step we can take?
Okay, even though he is non-contactable, but we know that he is still in occupation by virtue of the fact that his goods are still there,
Yep.
all right, and the tenancy agreement is still running until terminated. So the first thing is to ensure that the letter of demand, okay, it starts with a letter of demand, a formal letter of demand to be served on the tenant, okay, according to the service, the process of service that is stated in the tenancy agreement, all right. Even though it is not actually served personally or received by the tenant, it is deemed to be good service if you follow the process server provisions in the tenancy agreement, all right. So then once the notice is deemed to have been served on him, then the tenant cannot argue that he is not aware of it, okay, because it's a deeming provision in the tenancy agreement. All right. So let's assume that the notice has been served on him, and okay, the notice served on him is to, of course, to ask for the to demand for the overdue rental. All right. And then if he doesn't comply within a certain period of time, then probably the options that can be looked at, as I mentioned earlier, is either writ of distress, if you want the tenancy to continue, or eviction, if the landlord wants to terminate the agreement.
And in regards to eviction, evicting a tenant, what is the legal procedure?
Okay, for eviction, it's just that after the notice of after the notice to quit, has been served on the tenant, all right, he still remains there, all right, he still remains there. Then, of course, under the tenancy agreement, the landlord can opt for self-help measures, like breaking into the house and, physically coming into the house and recover possession. But that is not the right thing to do, all right? Under the law, to evict a tenant, the landlord has to go to court to obtain a judgment or order from the court first, all right? The eviction order, and to serve on the tenant, okay? So after serving on the tenant, then of course we'll see what happens. Is the tenant going to remain there, or is he going to leave? If he remains there on the premises, then the next step is to go for writ of possession, okay, to get this writ of possession from the court, so that the landlord is able to actually go into possession and recover the premises.
And how long does it take to actually evict a tenant? And just as important, how much does it cost to do so?
Okay, now I would say that the cost starts starts from $8,000 onwards. All right. Okay. I wouldn't tell you the maximum, because it all depends on whether the process is going to be resisted by the tenant or not, and also how much work is there to be done. But the landlord can expect a starting range of maybe 8,000 ringgit onwards. Yeah. And the process to evict may be a few months. A few months, yeah.
And if the landlord passes on, what happens to the tenancy? Can the tenant continue staying there?
Okay. The landlord has passed away, right?
Yep.
Okay. Now, that's why it's important that the tenancy agreement contains a clause on succession in title. This is a clause whereby it says that this tenancy agreement is binding on the successor in title and assigns and representatives of the landlord.
Okay.
All right. So when the landlord passes away, it is considered that the premises will go into the estate of the landlord. Okay, and by virtue of this successor in title clause, the successors in title of the landlord are are to continue with the tenancy agreement. All right.
All right.
Yeah.
And what is a sub-tenancy agreement? Maybe Chris, would you like to elaborate on the nature of this?
Okay, probably after that, Mr. Ivan Chan can also add from
Yes,
the
yes.
legal dimension.
Yeah.
But tenancy basically means that the landlord rents out a property to tenant A, and later on, tenant A, besides occupying the premises, he probably lets out another half of the premises to another party. Let's say, for example, a shop lot,
Yeah.
you know, ground floor. He initially rents the whole thing. Then after that, the tenant A sublet half of that to tenant B. Now this is from the estate agency practice. This is okay. We have a lot of cases like this as well. This is all right, provided that this is provided for under the tenancy agreement, and that the landlord also consents to this as well. Yeah.
All right.
So this is from the angle of the estate agent.
Legally?
Okay, it is very common to find a clause in the tenancy agreement that restricts subletting or assignment of the tenancy agreement to a third party. So it is prudent for the landlord to ensure that this clause is stated in the tenancy agreement, all right, so that it prohibits such what do you call it, sub-tenancy or assignment arrangement. Without this clause, then well, it is implied that tenant is able to sublet or assign the tenancy agreement without the prior consent of the landlord. Okay, yeah. So in almost all tenancy agreements, there is such a clause to prohibit subletting or assignment.
And can you tell us if there are any differentiation in the use of SOHO, SOFO, SOVO, and what are the limitations of the use of these premises?
Okay, this one I'll take this. Thanks for the question. Now this one is a very interesting one. Since the past few years, where developers have come up with very creative names, SOHO, SOVO, SOFO, and so on. They created a lot of confusion. A lot of people are still very mixed up up to today. Right. Although there are so many things that have been written about the subject matter. So if I can put it, I'll try to put it in a very simple format so that everyone will be clear once for all. First of all, let's get the acronym defined. SOHO is basically defined as a small office, home office. SOVO is small office, versatile office. And then SOFO, you have small office. SOFO, you have small office, flexible office, and so on. Now, under the existing laws and regulation of the country, SOHO and the like is governed under the Housing Development Act. Okay, small office, home office, because in the Housing Development Act is defined under the provisions of definition under housing accommodation. It's mentioned there that a property, a building that is wholly intended for human habitation or partly for human habitation and partly for business premises. So a SOHO fits into the latter because half can be used for residential, half can be used for business premises. So it's caught under the HDA, the Housing Development Act. So therefore, the purchases for that particular unit are accorded due protection under the Act. Whereas where you have SOFO, SOVO and the like, those are strictly for business premises only and not for residential use. And therefore, they fall outside of the ambit of the Housing Development Act, and they are not accorded to the standard sales and purchase agreement when the buyer first buys from the developer. It's not accorded the due protection from that. So hopefully I can erase all the doubts on this matter. So SOHO is under HDA because it's meant for half partially business premises or partially residential use, whereby SOFO, SOVO and the like are strictly for business premises and things like that. So therefore, in the tenancy setting, this should also be reflected accordingly as well in terms of the usage.
I see. All right. And Ivan, do you see short-term rentals like Airbnb and the like? Any future laws against such rental?
Okay, at this moment, we are all aware that Airbnb, okay, is a platform, okay, for homestay, and it is being practiced, okay, and even though there is no, to the best of my belief and knowledge, there is no regulation governing this platform, all right. Then again, there is also no express prohibition. All right, there is nothing to say this is against the law. All right, so so people just carry on becoming a Airbnb host. All right, but the thing to look at is that if a person wants to become a Airbnb host, they have to find out, okay, for example, if it is a unit in a condo, okay, the Airbnb host has to find out from the JMB or the MC whether such an activity is permitted or not in that particular condo.
Okay.
All right, okay. And if there are rules against this platform in that particular condo, then it is not allowed because the bylaws of that condo say so. All right, and what they call it, the owner would be wise to comply with the law. All right. At this moment, as far as I know, the relevant ministry, have not really come up with any intention or guidelines, to regulate this kind of what do you call that, short-term stay platform. So people are continuing just to do it, if there is no complaint, by residents, or if there is no dispute, then it just carries on, But then, but then again, it is important that if a person wants to go into this platform, this Airbnb business, they have to maybe seek information from the local authorities to see whether that is allowed in that particular locality and so on.
Yeah.
All right.
And before you leave, gentlemen, can you provide the viewers with any parting tips or advice, both for landlords and tenants as well?
I think I'll start that off. We have talked about the stakeholders at large, in this tenancy setting, landlord, the tenants. I also want to say that we can also sometimes learn from other countries. There's so many things that we can plug from other countries, best practices that we can also adopt in Malaysia. But one of the things I also want to recommend to the government is that probably we can look at like what they have in Australia, as I mentioned in my Star article recently, whereby you have the setting up of a national tenancy database, national tenant database, whereby whereby a landlord can actually look through the database of prospective tenants before they enter into a tenancy agreement with them, to make sure that the tenants are good, their backgrounds are all good and everything like that. So I think once you have this thing there, I think it will go very well. The tenancy process will be smoother. The checking mechanism at the initial stage will be much better. Because currently we still have things that we can check, as just now expounded by Mr. Chan. But if we have this, I think it will be much better for all of us here in Malaysia. So that's my parting note.
From you, Mr. Howard?
Okay. We hear people say that there's no such thing as a standard tenancy agreement, right?
Yeah.
So and because of that, a lot of times there may not be any legal representation, you know, for landlord and tenant. All right, but then again, but then again, I would say that it is essential for parties to be legally represented. Okay, so that their rights and obligations are clearly stated. Okay, and so that both parties can actually go into the agreement knowing, you know, the consequences, you know, of the contract, so that both sides are having legal representation, are aware, you know, of the consequences of breach, you know, and knowing what they are going into for. All right, so it's my opinion, it is recommended to go for legal representation in a tenancy agreement. Okay, even though some people say it's a standard agreement, you know, but then again, every tenancy agreement is not the same. You know, right? Okay.
All right, thank you, Chris and Ivan, for this very informative conversation.
Thank you.
And there you go, guys. I hope the nuggets of information from both Chris and Ivan will prove to be valuable to you. And as always, if you enjoyed the interview, don't forget to like our video or subscribe to our channel. Once again, I'm Jonathan Roberts from StarPropertyTV. See you next time.